good afternoon, everyone. I'm Meenakshi, and I'm delighted to welcome you all to today's live session on the crucial topic of what legal rights an employer should know. So, today our esteemed guest speaker is Mr. Nimish Chandra. He is an experienced lawyer who has been practicing since 2016 in the Supreme Court of India, Delhi High Court, and various subordinate courts and tribunals across India. So, um, his experiences includes collaborating with leading law firms and handling complex legal matters, and his expertise includes um, regulatory compliance and legal consultancies. So please join me in welcoming Nimish Chandra.
Thank you very much, Meenakshi, and good afternoon to everyone who has joined us today. It's a pleasure to be here to discuss the vital legal rights that every employer should know. Uh, Basically, understanding the employee's rights not only empowers the employee but also helps maintaining a positive and a respectful workplace for the organization.
Okay.
So,
So yeah. So thank you, Nimish, for setting the stage. So let's dive into our discussion with some crucial questions that we're definitely going to provide our audience with valuable insights. So recently, we have seen a wave of large-scale layoffs from major organizations, including Amazon, Google, Meta, and Twitter. So these are the high-profile cases that have brought harsh realities of mass firing into such sharp focus. So my first question to you is, what steps can an employer take when they are asked to immediately leave due to a layoff?
see, the first thing I would like to highlight is that the employment contract, which everybody signs before joining any organization, it should be treated as the gospel for all the employees. The first thing to refer during a layoff is your employment agreement and see the terms of the layoff. Apart from that, the layoff which has been told to you should be in a written form. If not, you should ask your employer to give it in a written form stating the basic reason why you have been laid off, the reasons for it. So basically, these two things are the most important things which you need to remember when anything of this sort happens. Apart from that, once an employee has been laid off, he should ask for the severance pay, which includes your basic salary. There might be some other compensations which would be mentioned in your agreement. Then, if an employee has worked in a company for like 1 year, so there uh, there should be a proper compensation, right? Apart from that, if an employee has worked for like 5 years, then gratuity should be asked from the employer. And apart from that, unpaid salaries and encashment, leave encashment, they should also be asked from the employer. So these are the basic things. Apart from that, when once an employee is laid off, the important thing that you need to remember is all the emails, the important emails regarding your layoffs, everything, every written document shall be printed out, taken with you before leaving the premises, which can help you if there's a sub legal advice or legal help you need. Then there has to be some evidence that the layoff is not unjust, and if it's unjust, then obviously you can always go to the courts.
Okay. So thank you, Nimish, for answering that critical question. It's been one of the most searched topics recently due to major layoffs from many organizations. And we appreciate your insights, and we hope that through this discussion, many of the employees would understand about their rights and what immediate actions they can take. So moving on to our next topic, let's discuss about workplace equality. So while many of the organizations have established maternity policies, paternity leave is it's not given much importance. So this disparity raises many significant questions about equal parental leave. So here's my next question to you: is there any legal entitlement for paternity leave similar to the maternity leave provisions under the law?
Okay. See, in recent times, even I have had a lot of inquiries regarding paternity leaves. But as of now, in India, there is no such policy or law which gives paternity leaves. Though maternity leaves has to be supported by the paternity leave, That was the basic concept of giving a maternity leave. But as of now in India, there is no such paternity leave, though there are some companies which do offer paternity leaves, but there is no such law in place at this current moment.
Okay,
Yeah.
that's very enlightening, Nimish. Um, yeah, this time there are no paternity leaves. That's unfortunately, but yeah. So let's move on to our next topic. So many of the employees face this issue when the companies alter their policies after they have been hired, especially if the policies at the time of hiring were different. So my question to you is what actions can an employer take when the company alters their policies after they have been hired, especially if the policy at the time of hiring were different?
Okay. So as I said before in the earlier question, your employment agreement is your gospel. So you will first have to refer to your employment agreement whether it states any term which speaks about changing of the policies.
Hmm.
If not, the second step should be you should reach the HR. Every communication with the HR department should be written. Why this policy has been changed? How is it impacting you? How is it impacting your employment in the organization? Apart from that, seek a proper clarification from the HR department. Everything which I state here should be in the written form. I'm stating it again. No verbal communication inside the organization should ever take place, even from the company's perspective and from the employee perspective. It should be written, documented properly, that why this amendment has been done, why the terms have been changed, and if there is any term which bothers the employee, then he should speak up to it and seek proper guidance from a legal consultant in case the company is not able to cure that difficulty which the employee is facing due to the change in terms.
Okay. Thank you, Nimish, for shedding light on this issue. Let's move to our next question. So, my next question to you is, what key compliance aspects can an employer verify before joining an organization?
See, this question basically is not dealing with the legal aspect as such. I state that because checking a company's credential and the compliances which the company has done or has been doing, nobody can check it, right? But what an employee can do is during his interview, during signing of the employment agreement, he can ask for the basic compliances, that whether he'll be getting the gratuity on 5 years completion, whether he'll be getting the paternity leave, whether he'll be getting the PF provident fund benefits. These things he can upfrontly ask to the HR department during his interview times.
आई थिंक
Apart
हो
from
जाएगा
that,
फिर फास्ट फास्ट है उसमें
uh,
क्लोज कर दीजिए
I think there's some disturbance. Yeah. Yeah. So apart from that, the employer obviously can refer to third parties, right? Previous employees, current employees of the company, and check with them how the company is working. Apart from that, checking the company credentials, I don't think it is possible for an employer. It is feasible also. But yes, these are certain aspects which can be asked upfront by the employee to the HR department.
Thank you, Ramesh, for answering this question. So let's move to our final question. It's kind of a very crucial one. So my question to you is, how should I manage a situation where my worker fails to honor the benefits and compensations at the time of hiring, uh, like there is a variable payment. There are variable pay components that were promised but not actually delivered.
So again, I'll come to the basic thing which I've said. Refer to your employment agreement. That's the basic. When you find any dispute in your employment, you have to refer to your employment agreement. See if any term is there in regards to the variable pay. Contact your HR. Again, it should be a informal mail. After sending the informal mail, go for negotiations. If the negotiations are reached, fine enough, good enough. If not, document everything and send them a legal notice. That's the only way you can settle your disputes with the company. Yeah.
Okay. Thank you, Nimesh, for your detailed guidance. Um, so, in conclusion, Understanding your legal rights is as an employer is crucial for navigating critical complexities of the modern workplace. And Nimish, thank you very much for your detailed guidance and expertise for and sharing your expertise with every one of us. And definitely your guidelines are going to help many of the employers to understand better about their rights and how they can protect them. And lastly, I would like to thank our audience for their participation. Hopefully this session would be very informative and helpful for everyone. Then stay tuned for further more insightful sessions from us. By the time, take care, goodbye, and have a great day.
Thank you, Meenakshi. Thank you.